All right, everybody. Welcome back to the channel, to the Butterfly Monkey Effect. This right here is a continuation of Passports and the Right to Travel, a study of administrative controls on the citizen. This is basically a history, and all you know. I'm going to continue again with court cases. There are a lot of court cases. I was looking over this last night, and it's like, damn. So I don't know what I'll do with the appendix. I might pick and choose which videos to do from the appendix instead of going through the whole appendix, because some of those opinions I already read. As if you guys know, some of the things that I even highlighted here have been repetitions of what they said pages earlier and so forth. And it seems like it's the same down there too. So we'll see when the time comes. But for sure, you got at least 10, maybe 12 videos just on what I want to read. So hopefully you guys are enjoying that stuff and learning stuff for sure to use in whatever proceedings that you guys have with passports and so forth. So to continue with further ado, right? The next case is Porter versus Herter, 1960, certiorari denied. So they didn't go to the Supreme Court. Appellate is a member of Congress representing the 4th Congressional District of the state of Oregon. On August 7, 1958, a passport was issued to him upon which appeared the following. This passport is not valid for travel to the following areas under control of authorities with which the United States does not have diplomatic relations. So you could just see, so this is 1960, and the last 3 court cases dealing with hostile countries or something like that, right? Now they have it as a given for his passport. Like, you know, it's like all these court cases are trial and error. It takes you to fight it in court to get some type of result. And then, of course, the statute and the process changes in light of that. But And that's what's bogus, too, because they're not supposed to pass anything that's unconstitutional. But they go and try what they could get away with for as long as they can. That's why so many court cases, they get away with it for so long before they get overturned. You know, the Chevron case is one of them. All right. This passport is not valid for travel to the following areas under the control of authorities with which the United States does not have a diplomatic relations: Albania, Bulgaria, and those portions of China, Korea, and Vietnam under communist control. On June 10, 1959, he applied to the Department of State for permission to visit Red China, asserting a member of Congress has the right to go anywhere in the world to do his duty as a U.S. legislator as he sees it, except in time of war or emergency. Any other policy would seem to be an unconstitutional breach of the separation of powers. Appellant's application was denied. So they did this to a fucking congressman. Appellant then instituted his suit in the district court, asserting that the secretary's action was in violation of appellant's rights under the Passport Act of 1926 and the Constitution of the United States. He asked for the injunction to restrain the secretary from withholding passport facilities and for other relief, and for an order compelling the secretary to remove the limitation. I think I went too far. This thing is really sensitive. Remove the limitation upon the appellate's use of the passport to travel to China. He sought summary judgment, but the district court granted the secretary's cross motion for summary judgment and dismissed the complaint. The appeal followed. The record before us demonstrates that appellant, as a member of Committee on Post Office and Civil Service in the House of Representatives, had been authorized to travel in behalf of the committee and in an official capacity to Okinawa and Japan to investigate personal problems of overseas employees. He had no comparable authorization from Congress, so he lied. He had no comparable authorization from Congress or from any of its committees to travel in communist China. So that means it's not part of his duty, right? There's not some specific thing. Just because he's a congressman, that doesn't make it a duty that he gets to go there, right? He has to have a specific duty from which, his job gave him to go there, right? So they're saying that he had a specific duty to go to Japan. Oh, man. Although he is a member of Congress, the status alone does not entitle him to be exempted from regulations or orders from the executive department in matters within the latter's constitutional competence. What's that? Foreign relations. We do not have before us a conflict between the legislative and executive branches of the government, in the course of which the respective branches assert and seek to apply opposing constitutional claims. The issue here is merely between a claim of an inherent right asserted in his individual capacity by a member of the legislative branch. So him using that he's a congressman, right? He's using that as a cover, as a front. Even the judge sees it that, dude, you're going to China because you want to go there. It's not because of some duty from your job. And the plenary power of the executive branch asserted by it in relation to and in its conduct of the nation's foreign affairs. Under such circumstances, the individual congressman must conform to the regulations pertaining to passports, which apply to all citizens and which have been authorized by the branch of government having jurisdiction over the subject. Viewed in this light, appellant's rights are not subject to the considerations discussed in Worthy, which they got denied too, right? We read that already. They give you 2 court cases, and all of them are getting denied. We deem the principles announced in those cases to be controlling here. Accordingly, the judgment of the district court is affirmed. And this is the other Worthy case, right? The other one was like 1957 or something, right? That's this one that they're talking about right here. Worthy versus Herter. William Worthy Jr., the appellant, is a newspaperman and lecturer. He was issued a passport in 1955. It provided that it was not valid for travel in the countries wherein designated, including Communist China and Hungary, notwithstanding the restrictions in his passport. Worthy traveled extensively in Communist China and Hungary. In 1957, he applied for a renewal of his passport. He was asked for a commitment, which he declined to give, that he would abide the restrictions. The removal of his passport was refused by the State Department. This action was upheld, and they give Worthy versus Herter. This decision was attached to the interest of the reviewers. I really don't know what they're saying there. This decision has attached the interest of the reviewers. I don't know, but here's a law review, a couple of them. Maybe that's what he's saying. Gotta look them up. Oh, I didn't mean to copy them. I'll copy them later. In the early summer of '61, Worthy advised his booking agent of his plan to visit Cuba, expressing the hope he could again visit China, saying he had competent legal advice and knew what he was doing, and requesting that his destination be kept confidential. On July 24, 1961, Worthy sailed on the SS Guadalupe of the Spanish line and left the vessel at Havana, Cuba. In October of '61, he arrived from Havana on a commercial airline flight at the International Airport of Miami. He was charged by indictment in the Southern District of Florida with unlawfully entering the United States without a valid passport in violation of United 1185B. And here's the crazy thing, right? It's as you've seen in the other videos, right? Earlier in this book, the passport is one as a request to the government that you're going to, right? The country that you're going to. The passport, right? The government, they have the right to regulate the passport, not your specific activity, right? So by you using, like, I know when I go and said this need to have the tier is this definition 85 it like right there it enters out of the passport, but you're coming from one of those countries are that whole catch, not country that is put out a valid passport. That restriction, that's the whole restriction behaves the that doing right to travel. He could have just went back to Venezuela, wherever he came from, right, where he went first, like, and then came home from there. But he chose not to. We'll see what they say. That's for sure my opinion on some other cases, right? But that's the way I'm looking at it, man. Well, here for sure, the earlier just in this book, they told you that it's that the context in that one case, having resolved against the appellate all the other issues, we are brought to the question as to whether the statutory prohibition with penal sanctions supplemented by an executive order against the entry of a citizen into the United States unless he bears a valid passport violates the rights of a citizen guaranteed by the federal Constitution. The right to travel outside the United States is a right which is within the protection of the Constitution. The Supreme Court has held the right to travel is part of the liberty of which the citizen cannot be deprived without due process of law under the Fifth Amendment. Freedom of movement across frontiers in either direction and inside frontiers, as well as parts of our heritage. Travel abroad, like travel within the country, may be necessary for a livelihood. It may be as close to the heart of the individual as the choice is what he eats, wears, and reads. Freedom of movement is basic in our scheme of values. Freedom to travel is indeed an important aspect of a citizen's liberty, and that's this is already I already done copied this probably like 3 times. It's a repetition because these are court cases citing the same thing. Like if they don't do that, right, and they just like this right here, this is a whole paragraph, right? Like stating it over and over again, like they have with other things in this book, right? Man, made this book 300 pages when it probably should have been closer to 200. Then I see that with plenty of other books. Like, they just repeat the same thing over and over and over. And they give you all these citations. Like, look, I never heard of this book right here. What the hell is this? This is the author. Antiwe, probably some French guy, Commentaries on the Constitution. Although the right of foreign travel may not be arbitrarily or unreasonably restrained, it is not an absolute right. Krauss versus Dulles. The right of the Congress to require passports and to impose reasonable restrictions upon foreign travel is not dependent upon the existence of a state of war, but may be exercised under the board, I think that says broad power to exact legislation for the regulation of foreign affairs. The authorities before cited, particularly the opinions of the District of Columbia Circuit in the Worthy case and the Frank case, have so fully developed the doctrines and principles which sustain the validity of the requirement of a passport for foreign travel and the denial of a passport to the applicant that we need do not more. What the fuck? That sounds like that. Sometimes I'm thinking it's my speech, right? Like I'm fucking up. But look at it, like that we need do not more with respect to such questions than to refer again to them, just stating them, right? But what did they just say? They just gave you the full doctrines for these two cases. So these two cases, like, should be a requirement, right? It should be a requirement to read as part of your research. Like it should be in your library no matter what. But I hate that shit, some of the language. Sometimes I think it's a misprint or something, but I don't know. That we need, do not more with respect to such questions than to refer again to me. And then again, it could be my English. Maybe this is proper and what I think is correct is is wrong, which probably it is. So I haven't studied like an English law, a book in a long time, like writings instead, specifics and grammar. It's been a good while. I have someone for that, and that's my better half. She does that. That's her thing. She has taken years and book, whatever, but she does that. The requirement and restrictions are applicable not only to Worthy and Frank, newspapermen who asserted rights of freedom of the press under the First Amendment, but also to a congressman who claimed the restriction was a breach of the separation of powers. And of course, that's the case we just read, Porter versus Herter, certiorari denied. Since Congress has the power to declare a policy with respect to foreign affairs and to oppose reasonable restrictions on the right of a citizen to travel in foreign countries, it follows that it may punish violations of the statute. Let me highlight all this stuff. I got to highlight this because when I look at this, because I'm on my computer, when I look at this on my phone, it updates. It updates to what I did on my computer. So I don't have to read the whole damn book on my phone no more. All I have to do is see what I copy and, I'm pasting, I'm highlighting and so forth. And they said, see hide versus shine for punishment, that it's valid to do that. The prohibitory provision of Section 1185B defines the offenses in the alternative and makes it unlawful for a citizen to depart from or enter the United States unless he bears a valid passport. In the conviction of the appellant had been for willful departure from the United States without a valid passport, we would be confronted with a less difficult problem, right? Because you have the right to do that. You just cannot go to that specific country that is applicable to their foreign affairs agenda. A citizen at an airport or pier without a passport can refrain from a violation of the statute by remaining in the country. So doing, the citizen can continue to exercise all of the rights and privileges of a citizenship and enjoy the protection afforded to him by constitutions and laws incident to his citizenship. The situation of a citizen outside the United States or at a port of entry without a passport is different. He can resume the enjoyment of the citizen's rights and privilege only by the commission. He can resume the enjoyment of a citizen's rights and privileges only by the commission of a criminal offense. I think that's wrong right there. He said he can resume the enjoyment only by the commission. The appellant had it within its power to avoid a violation of the prohibition against unlawful entry by refraining from an unlawful departure. But the penalty for an unlawful departure is a fine or imprisonment or both. And the offense of unlawful departure does not include the offense of an unlawful entry. Neither does an unlawful entry include an unlawful departure, although it may be improbable that an entry would be unlawful if the departure was unlawful. The two offenses are separate. The appellant was not charged with an unlawful departure. But the way he said it up here, right, the citizen, right, because look, he first says, if the conviction of the appellant had been for a willful departure, we would have a difficult we would be confronted with a less difficult problem. A citizen, but his analysis of it, right? The citizen at an airport or pier without a passport can refrain from a violation just by staying in the country, right? The voluntary act of leaving right? But they don't say the context. That's the whole thing. They're not stating the destination. The appellant had it within his power to avoid a violation of the prohibition against unlawful entry by refraining from an unlawful departure. But the penalty of unlawful departure is a fine. Well, I'm not going to read all that because I just did. I thought I didn't for some reason. In Browder versus the United States, convictions were sustained for using passports secured by false statements where the passports were used for the purpose of establishing identity and citizenship and the consequent right of entry into the United States from abroad. The offense was the use of passports fraudulently secured and not the act of entering the United States. If citizenship and identity had been established by other means than the passports, no offense would have been committed, at least not the offense of which the convictions were had. These decisions are not authority for sustaining the conviction of the appellate. So they're shooting down the prosecutor right there. Let me get something to drink. The United States, by 18 U.S.C. 1407, has made it a criminal offense for narcotic addicts and violators to depart or enter into the United States without registration at a point of entry or a border customs station. What? So they got, I never read this statute. This, because this is 18, this is not in the passports, right? But it applies for the border. Has made it a criminal offense for narcotic addicts and violators to depart from or enter into the United States without registration. What do you think this falls under? Earlier, they said that a citizen basically received all privileges and immunities of that the Constitution affords, except what? Vagabonds, paupers, and fugitives of justice. What do you think an addict or a violator of such drugs is? He's a vagabond. This falls within their scope. They don't want drug addicts in another country for whatever purpose, public appearance, whatever foreign relations stuff they're going to come up with. This provision has been sustained in Palma versus the United States. They give you like 3-4 of them. This is why they have those provisions in Title 22 now. All these court cases reaffirmed whatever this punishment is right here, because there's a penal one, right? And it's now in 2020, Title 22, where you can't do it at all if you have those charges, those convictions and all that stuff. The offense prescribed by the Narcotics Act is the failure to register, not the entry as in the case before us. We get but little aid from these decisions in our search for a solution to the problem here posed. It's crazy. It looks like he's looking for the way for, he's looking for to overturn the conviction. The way he's breaking it down. We think it is inherent in the concept of citizenship that the citizen, when absent from the country to which he owes allegiance, has a right to return again to set foot on the soil. It is not to be wondered that the occasions for declaring this principle have been few. And in United States versus Ju Toy, it was assumed that to deny entrance of a citizen into the United States was a deprivation of a liberty secured by the Fifth Amendment. In the dissenting opinion in that case, it was said that it is no crime for a citizen to come back to his native land. In another case, the Supreme Court gave recognition to the principle, saying, in all the states from the beginning down to the adoption of the Articles of Confederation, the citizens thereof possess the fundamental right inherent in all citizens of all free governments peacefully to dwell within the limits of their respective states, to move at will from place to place therein, and to have free ingress thereto and egress therefrom, with a consequent authority in the states to forbid and punish violations of this fundamental right. And they give you Wheeler, and they give you the slaughterhouse cases. We do not think that a citizen absent from his country. So remember, this court case is, again, he leaves on a boat and goes to South America, and then from there he goes to Cuba, and then from Cuba he jumps on a plane and comes to Miami, right? So it's entry from Cuba is the issue. We do not think that a citizen absent from his country can have his fundamental right to have free ingress thereto, subject to a criminal penalty, if he does not have a passport. The citizen, culpable though he may have been in leaving his country without a passport, which he could not obtain, and subject as he, the citizen, culpable though he may have been in leaving his country without a passport, which he could not obtain, and subject, as he probably was, to a criminal penalty for departing without a passport, cannot, we think, be required to choose between banishment or expatriation on the one hand, or crossing the border on the other hand, being faced with criminal punishment and the loss of some of the rights and privileges of citizenship as a felon. Citizenship, the Supreme Court has recently said, is the most precious right expressly guaranteed by the 14th Amendment of the Constitution. I think this is leading up to what it really is as today, meaning you cannot come back from that country without that passport, and that's the penalty. I don't know, because that actually, this does have that. I don't know. It doesn't look like it because it's about that. We are not aware of the reluctance with which the courts should reach decisions declaring enactments of Congress to be unconstitutional. We realize, though, the duty resting upon the judiciary to protect the citizen in the exercise of the fundamental rights which the fundamental law has conferred upon him. In the performance of that duty, and for the reasons which have attempted to state, it is our conclusion that the government cannot say to its citizen standing beyond its borders that his re-entry into the land of his allegiance is a criminal offense. And this, we conclude, is a sound principle whether or not the citizen has a passport. And however wrongful may have been his conduct in affecting his departure, the judgment and sentence of the district court will be reversed and the cause will be remanded for the discharge of the appellant. This is a case that I for sure would want to go shepherdize. I want to know the negative aspects that came out of this, which might be here. So we'll find out. So this case right here, next case, I'm going to continue. I'm not stopping yet. Hopefully I'll be under an hour. I don't know. It's at 28 minutes now. So Aptheker versus Secretary of State, 1964. Appellates, native-born citizens, and residents of the United States are ranking officials of the Communist Party of the United States. After hearings under State Department regulations, appellates' passports were revoked under Section 6 of the Subversive Activities Control Act of 1950, which provides that when a communist organization is registered, or under final order to register, it shall be unlawful for any member with knowledge or notice thereof to apply for or use a passport. Appellants filed suit asking that Section 6 be declared unconstitutional as a violation of the Due Process Clause of the Fifth Amendment, and that the Secretary of State be ordered to issue passports to them. A 3-judge district court denied relief. He lost. The district court held that Section 6 is a valid exercise of the power of Congress to protect and preserve our government against the threat posed by the world communist movement, and that the regulatory scheme bears a reasonable relation thereto. In the Supreme Court, the court noted that appellants attack Section 6, both on its face and as applied, as an unconstitutional deprivation of the liberty guaranteed in the Bill of Rights. The government will, while conceding that the right to travel is protected by the Fifth Amendment, contends that the Due Process Clause does not prevent the reasonable regulation of liberty, and that Section 6 is a reasonable regulation because its relation to the, you already know. Man, I keep going too far. Because of its relation to the danger of world communist movement presents for our national security. Alternatively, the government argues that whether or not denial of passports to some members of the Communist Party might be deemed not reasonable related to national security. Surely, Section 6 was reasonable as applied to the top-ranking party leaders involved here. We hold, for the reasons stated below, that Section 6 of the Control Act 2 broadly and indiscriminately restricts the right to travel and thereby abridges the liberty guaranteed by the Fifth Amendment. In stating its reasons, the court stated in part that the right to travel abroad is an important aspect of the citizen's liberty guaranteed in the Due Process Clause of the Fifth Amendment. By its plain import, Part 6 of the Control Act effectively prohibits travel anywhere in the world outside of the Western Hemisphere by members of any communist organization, including Communist Action and Communist Front organizations. The court pointed out that there are well-established principles by which to test whether the restrictions here imposed are consistent with the liberty guaranteed in the Fifth Amendment. It is a familiar and basic principle that a government purpose to control or prevent activities constitutionally subject to state regulation may not be achieved by means which sweep unnecessarily broad and thereby invade the area of protected freedoms. In applying this principle, the court in the NAACP versus Alabama refer to the criteria enumerated in Shelton versus Tucker. Even though the governmental purpose be legitimate and substantial, that purpose cannot be pursued by means that broadly stifle fundamental personal liberties, when the end can be more narrowly achieved. The breadth of legislative abridgment must be viewed in the light of less drastic means of achieving the same basic purpose. I'm gonna highlight this because he's calling this a principle. This principle requires that we consider the congressional purpose underlying Section 6 of the Control Act. Thus, the terms of Section 6 apply whether or not the member actually knows or believes that he is associated with what is deemed to be a communist action or a communist front organization. The section also applies whether or not one knows or believes that he is associated with an organization operating to further the aims of world communist movement and to establish a totalitarian dictatorship in the countries throughout the world. And what did they just state here? Their intent, meaning it's not you just hanging out with your friends or an idea that you have in your mind. This is intent being put into action now. These are your thoughts putting it into action. The provision therefore sweeps within its prohibition both knowing and unknowing members. In related contexts, this court has had occasion to consider the substantiality of the relationship between an individual and a group, whereas here, the fact of membership in that group has been made the sole criterion for limiting the individual's freedom. In Wyman versus Uppendergraf or whatever, chop that up, the court held that the due process guarantee of the Constitution was violated when the state, in an attempt to bar disloyal individuals from its employ, excluded persons solely on the basis of organizational memberships without regard to their knowledge concerning the organizations to which they had belonged. The court concluded that indiscriminate classification of innocent with knowing activity must fall as an assertion of arbitrary power. Section 6 also renders irrelevant the member's degree of activity in the organization and his commitment to its purpose. These factors, like knowledge, would bear on the likelihood that travel by such person would be attended by the type of activity which Congress sought to control. As the court has elsewhere noted, men in adhering to a political party or other organization notoriously do not subscribe unqualifiedly to all of its platforms or asserted principles. In determining the constitutionality of Section 6, it is also important to consider that Congress has within its power less drastic means achieving the congressional objective of safeguarding our national security. The Federal Employee Loyalty Program, which has before this court in Joint Anti-Fascist Refugee Commission or Committee versus McGrath, provides an example. In our view, the foregoing considerations compel the conclusion that Section 6 of the Control Act is unconstitutional on its face. The section, judged by its plain import and by the substantive evil which Congress sought to control, sweeps too widely and too indiscriminately across the liberty guaranteed in the Fifth Amendment. The prohibition against travel is supported only by a tenuous relationship between the bare fact of organizational membership and the activity Congress sought to prescribe. The broad and enveloping prohibition indiscriminately excludes plainly relevant considerations such as the individual's knowledge, activity, commitment, and purposes in the places for travel. The section, therefore, is patently not a regulation narrowly drawn to prevent the supposed evil. And they give you another, Cantwell versus Connecticut. Yet here, as elsewhere, precision must be the touchstone of legislation so affecting basic freedoms. And they give you the AACP thing again. This is big, right? Because what was it was like 4 cases earlier, right? They state the specifics that Congress gave, right? What was the specifics on passport use and stuff like that, which was citizenship and criminal activity and shit like that. Well, like that's why it's important that he's bringing up that Congress must bring up something of a narrower scope, right? You have to consider the individual's knowledge, activity, commitment, and purpose in and places for travel. In on top of them being a part of the membership, right? Because that's the context of what they're trying to control his travel on. Right? That not to say that applies to someone specifically, just a general smunk trying to go somewhere. This applies specifically because it's Section 6 and it's trying to control the movement for those purposes. The government alternatively urges that if Section 6 cannot be sustained on its face, the prohibition should nevertheless be held constitutional as applied to these particular appellants. The government argues that surely Section 6 was reasonable as applied to the top-ranking party leaders involved here. It is not disputed that appellants are top-ranking leaders. Appellant Apotheker is editor of Political Affairs, the theoretical organ of the party in this country, and Appellate Flynn is chairman of the party. It must be remembered that although this court will often strain to construe legislation so as to save it against constitutional attack, it must not and will not carry this to the point of perverting the purpose of the statute or judicially rewriting it. which kind of what he did, right? He just said that. He's like, yeah, it's unconstitutional, but it should not, it should apply to these motherfuckers right here. To put the matter another way, this court will not consider the abstract question whether Congress might have enacted a valid statute, but instead might ask whether the statute that Congress did enact will permissibly bear a construction rendering it free from constitutional defects. The clarity and preciseness of the provision in question make it impossible to narrow its indiscriminately cast and overtly broad scope without substantial rewriting. For essentially the same reasons this court had concluded that the constitutionality of the statute in Thornhill v. Alabama should be judged on its face. An accused, after arrest and conviction under such statute on its face unconstitutionally abridging freedom of speech, does not have to sustain the burden of demonstrating that the state could not constitutionally have written a different and specific statute covering his activities as disclosed by the charge and evidence introduced against him. Similarly, since freedom of travel is a constitutional liberty closely related to rights of free speech and association, we believe that appellants in this case should not be required to assume the burden of demonstrating that Congress could not have written a statute constitutionally prohibiting their travel. Accordingly, the judgment of the three-judge district court is reversed and the cause remanded for proceedings in conformity of this opinion. So they're going to lose anyway because all they're going to do is rewrite it. And the way he's speaking on is the way his opinion came is that he showed that Congress had an intention, right? But they didn't limit their scope. So all it is going to be is just going to be rewritten. Okay, and with that, I'm going to end it for this video. But this right here, Zemo versus Rust, this is a good case too. So that's 65. There's a handful of great court cases that have updated what we have known and now understand on passports and the right to travel and stuff. So we'll see right now. So hopefully you guys enjoyed that. You know, this 42 minutes is pretty good. Hopefully I didn't put you guys to sleep. Hope you guys learned something. If not, I don't know what to tell you, but you guys should have access to the document either way. So thanks for listening. And of course, share, like, join my Telegram, join my YouTube, join my TikTok, and whatever other platform I might be getting on. All right. And with that, take care of you guys.